Hey guys, how you doing today? Hope your day is going well. Today I wanted to talk about the trial of Amber Guyger. She's a police officer down here in Dallas who's on trial for murder. She basically went to the apartment above hers, went into that apartment uh, when the owner, the resident, Botham Jean, approached her, confronted her. She shot him with her service pistol. She was still coming off of her shift as a police officer, and she shoots him dead. Um, she was indicted for murder, and now she's on trial for murder. And I see a lot of misinformation from the Dallas, from the Facebook, from the Dallas news, from everything. People are really confused. People want justice, and that's understandable. But I thought I'd give my 2 cents as a defense lawyer as to what's going on, what you can expect. So first off, none of this has anything to do with what I think about Amber Guyger or Botham Jean. Just to caveat, I think Amber Guyger is a very selfish person. All cops are people, and Amber was listening to that 911 tape. All she cared about when she shot this man in his home, she wasn't worried that she shot a man dead in her home. She was worried that she was going to lose her job. That's all she cared about is herself. So I'm going to caveat with that. I don't think she's a good person, but that's not what I'm here to talk about. I'm here to talk about the law. I'm also not going to talk a lot about the race relations or anything like that. I'm going to talk more about the legal aspects for you, maybe clear some things up. So first off, me personally, this is just my legal opinion. I think she's probably going to walk. I would give it 75%. I've been wrong. I think if she, when politics gets involved, when things like race get involved, that it's really hard to nail down what a jury's going to do. It's a very diverse jury, more diverse than I can usually ever get for my clients of color or any other clients. But it is a very diverse jury, and Dallas County is a huge county, and they could come from all across the county, from various different locations, from wealthy, well-to-do neighborhoods all the way to slums. So it will be hard to tell, but I think that probably Amber Guyger is going to get off, and here's why. She's charged with murder, okay? And in Texas, murder is when you with the intent to cause serious bodily injury and commit an act clearly dangerous to human life, cause the death of that individual. So that's basically when you aim a gun at someone and shoot them, whether it's to, quote unquote, whether you're saying, want to kill somebody. There's other definitions, but this is the one that I think applies here, because whether Amber Guyger thought she was in danger and was just trying to stop that person, it was like, I wasn't trying to kill him, I was just trying to stop him. Doesn't matter. Shooting someone is clearly dangerous to human life, and that action she did intentionally. Everyone is confusing intent and mistake, and I'll try to clear that up. I don't think that there's any question that she intentionally shot Botham with the intent to cause serious bodily injury. That's why you shoot someone, to stop them. You stop them by causing serious bodily injury, and everyone knows especially police, when you shoot someone, there's a good chance they'll die. So there's no question of the intent when she shot, the intent of her actually pulling out and shooting. Okay? So there's no question there. So why is it a difficult case? Why isn't that just in there? Well, because there's defenses available in Texas. Self-defense being the main one here. There's defense of others, defense of properties. All we're worried about here generally is going to be self-defense. She thought there was a burglar. She's going to say that she thought there was a burglar in her house, and that burglar approached her yelling, which would be a proper defense. Now, everyone goes, what, are you crazy? She wasn't in her house. That's where mistake comes up, and this is where people get confused, mistake with intent. The law allows for mistake of fact. So basically, if you reasonably believed that someone presented a danger, so here, if Amber Guyger convinces the jury, she reasonably believed that Botham was an intruder in her apartment and that he was coming towards her, then that would create a fear for life, and that mistake of fact would render a defense of self-defense. In other words, self-defense is what the person who is using it thought. The person who did the shooting, the person accused of the crime, has the defense, accused of murder, has the defense of self-defense if they can convince the jury that mistake was reasonable. So all that matters is what went on in Amber's head. And I'll just tell you, I think it will be very, very difficult to not have a doubt, to have a doubt that she thought she was in her own apartment, and that if she was in her own apartment, that what she did was reasonable. Because I think there's nobody in the world who thinks that if she had walked into her apartment and seen the guy coming at her, that she can shoot him dead here in Texas. It's not even close. It's not a question. So the question is whether the mistake was reasonable. I think based on the evidence, there's no question that she thought. They haven't presented any, the trial's not over, but so far I have heard of not a single bit of real evidence that she was not mistaken. Okay? That I haven't seen any evidence that she really did think it was someone else's apartment. None of that makes sense. The only story that makes sense is she went into somebody else's apartment thinking it was hers. So now to the mistake. The jury can still say that her mistake was unreasonable. Now everybody's asking, okay, well, so maybe it's not murder. Maybe they overcharged it. I don't think so. Again, there's no doubt she did something that was clearly dangerous to human life in shooting him, and that she did so intentionally. So let's go over manslaughter. Let's say she had just shot through the door at someone that sounded like they were breaking in. And it just turns out that it was a mistake. Someone wasn't breaking in. They were just like trying to move a couch and banging against the door. That would be manslaughter. She didn't intend to kill that person. She intended to scare them or something like that. But she recklessly caused the death of another. Okay? The next one is criminally negligent homicide. Now that's when a person causes a death through criminal negligence. So this is the definition that we usually use is speeding. Speeding usually doesn't cause death. It's known, but just negligent. Or if you leave something open, that goes up to criminal negligence. So I would say, so you're speeding down the road at 150 miles per hour. Well, that's negligent driving, criminally negligent driving. And so when you kill someone, it's not really manslaughter. You weren't driving knowing that you were going to kill someone. You weren't driving trying to kill someone. You were just criminally negligent in your operation of that motor vehicle. So that's the criminal negligence part. The problem is mistake is a defense to all of these. Criminal negligence, I don't even know there is a mistake. And to get to those, you have to manslaughter, mistake would be available. They're not really appropriate. What she did here was certainly under the guise of murder if she was not reasonable. So in other words, if the jury doesn't buy her story and says it was not reasonable what she did, then she is guilty of murder and they should find her guilty. If the jury doesn't think that, they think she was in there, then that's a mistake. And you can't just go down and go, okay, well, but it was negligence. No, it wasn't. If it was negligence, then then you don't think it was reasonable. So I don't think you can do those two things. Now, that's just my legal appraisal. The jury can do whatever the jury wants. And this will be up to the state. I don't see the defense as asking for lesser included, because you're just asking the jury to split the baby and convict your client of something. I think therefore, that leaves just the state, and the state can just ask for it. They don't have to prove it was presented in a case. They can just ask for it here in Texas. Look, if the state asks for it, for a lesser included, then they are just giving in that they're not going to get murder. They're just saying, yeah, we understand we didn't meet our burden. We think there was a mistake, but we want you to split the baby and find that she was negligent. Because that's probably what the jury will do. If given the chance, if the defense can't convince them, can't explain to them mistake. All right. So that's going to be up to the state whether they do or not. I think maybe they will because they want a conviction. But at the same time, I think that if the jury is able to answer, if they're given and able to answer the mistake, I think they're going to answer that it was a mistake, and that's going to nullify anything else. I don't think that it would be proper to find her guilty of anything else if there was a mistake. Legally proper, I mean. It would be something that would be appealable, or maybe even the judge wouldn't allow it. So that's my appraisal of this case as it stands so far. Again, maybe there's a bombshell. Maybe they have reason to believe that she did have a vendetta against this guy. But what I want to say is it's a result that nobody wants. And unfortunately, in our feeling how crazy this is, in our feeling that she should have known, you just can't go into an apartment and shoot somebody. For sure you can't. But the law says, and I really think if you really are reasonable, you would agree that if it was just a mistake, that there is no intent. It was simply. Now, whether that is you are criminally negligent in going into someone's apartment, I don't think there's a criminal element there. If you get into somebody's car that's exactly like yours at the parking lot, you're not criminally negligent. Now, if someone shoots you doing that, then they get off. You went into their car. You may not be robbing them, but they're, again, mistake of fact. They would think you're robbing them and therefore mistakenly shoot you thinking you're a robber instead of just some poor person who was getting in the wrong car because y'all have identical cars. If they find mistake, I do believe you can't get to criminal negligence because I don't think that mistake of going to the wrong apartment is criminal in nature. See what I'm saying? It's not speeding. It's not knowing. When you go into the wrong apartment, I don't think anybody thinks, this could result in somebody's dying. The problem is it did. And sometimes there's freak accidents. And when there's politics involved, race, law enforcement, everything going on, people want something to happen. The problem is the way we structure our law is to take the emotion out of it. And in doing so, we may leave the jury with no choice, as I think is going to happen in this one. But having said what I said at the beginning, she was very selfish. She obviously did a stupid thing. She was not worried about her poor victim, and therefore I do believe she gets what she deserves. Well, I appreciate you listening to this. If you stayed all 15 minutes, patelfuller.com, 214-810-3120. If you're facing something like, by the way, I think I could have done a way better defense opening statement than her defense counsel did. I think they actually just a little bit dropped the ball. I think I could have done better. But regardless, if you are in trouble, if you need any legal trouble, we do civil, we do criminal, we do everything. patelfuller.com. Thank you very much for listening. I hope it was helpful. If you have any questions, you can hit me up on Facebook, hit us up on Facebook, through our website, call us, whatever you need, just to even talk about this. Comment below here on YouTube. So thanks for watching. Have a good one.